Welcome, everyone, to this presentation on the brand new Contingency to Contract and Close form update for the Bluegrass Realtors. My name is John Rompf, and I'm an attorney at the law firm of White, McCain, and Stewart. I've had the privilege of working with both the Forms Committee and the Board of Directors on this new form that I'm excited to share with you today. Let me begin with a disclaimer by letting you know that neither this new form nor this presentation are intended to be legal or tax advice regarding any particular situation or transaction. I would encourage anyone who is watching this video or relying upon this form to consult independent professionals about any specific questions they may have about a specific transaction that they are dealing with and how this form may impact that transaction, either for tax purposes or for legal purposes. As everyone is aware, this is a brand new form. It's going to replace our existing kickout form. And really, we're aiming at addressing a number of concerns that were repeatedly being brought by membership about the lack of efficiency of that form and dealing with the variety of situations that come up when a buyer wants to purchase a piece of property, but wants to do so contingent on their ability to sell another piece of property. It has been the common practice within our membership to utilize a couple different forms in these scenarios. And our hope is to replace the existing forms with a new form that more comprehensively deals with the particular situations that arise under those circumstances. So I would like to get into the nitty-gritty details with this. But the first thing that I would suggest is that you really familiarize yourself with this form. So if you're watching this for the first time, and you've not seen this form before, the first thing that I would suggest that you do is actually pause the video and read through the form in its entirety. This form really causes one needs to have an understanding of how the different sections interrelate with one another to really comprehend the full meaning of each section. And what is important, I think, holistically to understand is that really we're dealing with two separate contingencies when this form is being utilized. We're dealing with the buyer's contingency to get their current home under contract, but we're also dealing with a separate contingency for them to close on that contract if they're able to do so. And our prior form was not very effective at separating out those two separate contingencies and making clear, A, that those were two separate things, that both of which needed to be released, and B, setting the parameters on the process for what that would look like for both the buyer and the seller. So this form is an attempt to do that. We've done a kind of a study of how other folks in different jurisdictions and different MLS or associations handle this situation. And we've also taken into consideration feedback from members as well as experience within the marketplace. This is obviously the first iteration of this form. We expect that we'll get a lot of feedback related to it, but our hope is that it's a dramatic improvement over what we've currently available in the forms directory. And our hope is that this will help streamline this process, not only for agents, but for your clients as well. So the first section I'm going to highlight is the new disclaimer here at the top. The naming of this was done deliberately so that when you're searching for it, whether you're using kind of the old terminology of a kickout or you're using kind of our new terminology about contingency to contract and close, you should be able to locate this form. So the name was intentional. We know it's really long, but we also know this is kind of a big change for people. People are used to thinking of this as the kickout form. So we didn't want to entirely get rid of that name, but really we want people to understand and focus upon the fact that this is actually creating two separate contingencies. The rest of this disclaimer, if you've watched any of our other update forms, video presentations, is really to remind both agents and consumers that all of these forms can have significant tax and legal consequences. And we encourage consumers to consult with appropriate professionals about their circumstances before they enter into any of these agreements. The next section that I want to highlight, although it appears to just kind of be common boilerplate language, it actually is quite legally significant and people need to understand its impact. This form is intended to be used as a contingency form to the contract. It is not intended to be used on its own, and it's intended to relate back to the contract. And that is why we're asking, as was the prior practice, to identify the contract it's relating to, a property address by contract number, and also by identifying what buyer's property has to be sold. It's important because it's also doing a number of other things. One, it is making sure that the definitions in this form are all the same as the contract. Two, it is making it very, very clear that time is of the essence with regards to the dates, times, deadlines that are found in this form. As all of you are aware, that is not the case in the contract unless you specifically choose to make it so. But in this form, because of the nature of this form and the processes it affects, the decision was made to make time of the essence as it relates to this form. The next important thing is that this form is not intended to alter anything else set forth within the contract. The deadlines and timing in the contract remain in effect. Practically speaking, this has significant implications as it creates a situation where due diligence periods will likely have to be extended in the contract. But the alternative of making the timelines not contingent on those in the contract is you end up in a situation where there's really no definite deadlines for the buyer to begin their due diligence on the new property, or at least not in a way that's time sensitive to the needs of sellers. So the decision was made to make the deadlines in the contract remain applicable. That is going to require agents to keep track in the early stages when due diligence may expire to extend those periods of time based upon this contingency form still being in place. This is probably the most important thing from this first section for you to understand, is that it is very, very important to make sure that the buyer's due diligence periods do not lapse just because this contingency period is in effect. The last sentence that I'll draw your attention to is found in line 11, and that is making it explicitly clear that while the contingency to contract for sale and closing is in effect, sellers may continue to market the property. Next section has to deal with making sure that the buyer's property that they need to sell is getting listed and getting listed within a very specific time frame. So there's two selections here. Either one, in part A, the buyer is disclosing the property is listed and who it's listed with so that the sellers can confirm that. And then B, the second option is the commitment of the buyer to get their buyer's property listed by a date definite and to provide the seller's agent with notice of that. And if they don't do so, allowing the seller the option to void by giving notice. And the purpose here is to make sure that the process of getting the buyer's property listed takes place very quickly and within a time period that's defined by the agreement. The second section here is having to do simply with the first contingency of the buyer getting a contract for the sale of their property. So part one, buyer gets their property listed. Part two, buyer works to get a contract. It is important because this deadline set forth in paragraph 2 in line 21 is kind of the drop date for when the buyer has to have the property under contract. If they do not have it under contract by that time, and this is not extended by a mutual agreement of the parties, then the parties are going to sign a release of the contract and escrow is going to be returned to the buyer. So this is creating a window of time for the buyer to obtain a contract. This is important because it sets a definite date, and all of the other deadlines from this agreement are really going to flow from that date or interrelate with that date. So the first contingency, again, is to make sure that the buyer obtains a contract for their property that they have to sell. That is the basis for the contingency. Sets a drop kind of dead date for that timeline. Section 3 then talks about what happens prior to that deadline. Traditionally, we've kind of had two options and really maybe three that are common in our marketplace. And we've kind of tried to identify those as what they are. Option A, identified in lines 24 through 31 of this form, is what we're going to call the immediate kickout. This is the situation where, yes, seller agrees to a contract and it makes it contingent on buyer selling other property, but seller says, I have the right to immediately kick out your contract in the event I receive another offer that does not contain such a contingency. So we've tried to make it very explicit that if the seller obtains another clean, what I'm calling a clean offer, doesn't have a contingency for the buyer of that new offer to sell their existing property, then they can immediately kick out this contract. That is obviously the most, I would call it, seller favorable provision. It allows, yes, we're going to give you some period of time, 3 days, 7 days, whatever, to get new buyer your property under contract. But if you don't do that, we can immediately kick you out if we receive another clean offer. Option B, which is lines 32 through 43, is what I would call a kick out with notice. And this is a situation where buyer and seller want to agree that yes, seller is going to continue to market the property. Yes, buyer is going to continue using their best efforts to get their other property under contract by the contingency to contract to sell deadline. However, if seller is able to get another clean offer during that window of time, seller is going to have to give notice to the buyer, and the amount of notice is left blank in the terms of hours, but they're going to have to give notice to the buyer that they're going to have to release these contingencies. And it's kind of two different choices. They can release both contingencies, which would be the contingency to get a contract and the contingency to close, or they can release one of those contingencies. They can release, and it would be just the contingency to get it under contract. The purpose of this section is to allow for a situation where the prospective buyer is able to get their property under contract to sell, but they're going to retain the right to have that sale close. And this is important, and I think this is where disputes in our old forms most commonly arose, where, yeah, the buyer is able to get a contract, get their property under contract to sell it. But in order for them to be able to obtain the financing they intend to utilize in the primary purchase contract, they actually have to have that sale close. They need it for their down payment, or they needed to get it off their debt schedule, whatever the situation may be. And so even though there's a release of the contingency to get a contract, they still need to make their new purchase contingent on the closing of that other contract. I'm sure all of you have dealt with this. This is something that swings when the pendulum of the market swings, but right now we're in a situation where it's very common, particularly in the last year, to have purchase contracts contingent on the sale of other property. And some of you, I'm sure, have experience with these being stacked up, maybe three or four closings in a row stacked up where they're all contingent on the prior one closing. And so it's very common to find ourselves in this situation. And this form is an attempt to essentially allow, yes, we're going to allow kick out with notice, and we're going to have two options when that occurs: release just the contingency to contract, or release both. And the buyer will move forward with closing without their contract being contingent on either of those conditions. So this is an attempt to really keep the options open to the parties to negotiate what solution works better in their situations. The third option that we've added is option C, and this is really not a kick out at all. This is a situation where the buyer and the seller agree that we're going to have a contingency to get a contract, and we're not going to allow the seller to terminate that at any point in time prior to the deadline set forth in Section 2. I envision that this would be utilized in circumstances where maybe the seller wants to agree to a contract on a Monday, but they want to only give the new buyer maybe through the weekend in order to get their new property sold. The buyer says, hey, we've got 5 people interested. We just don't have a contract yet. We expect we're going to get it quickly. The seller doesn't want to have their property tied up forever. So they're going to say, hey, we'll accept it, but we're going to put a pretty short window. And, because of that short window, the parties just agree, we're not going to have a kick out during this time because it's such a short window. I would think this would not, this would probably be the least common option chosen, but I do think it allows some flexibility to not have to worry about releasing all these things in terms of releasing both these other contingencies, because we're going to create a very short window for this occur. So it's kind of creating a third option for the parties to negotiate that actually streamlines it probably the best if it's a very short window of time. So it allows the parties the freedom to not have the pressure maybe on the buyer's side, and the seller not to have an extended window, and they'll know, hey, this contingency is going to lapse pretty quickly. Moving on to page 2, and this was intentional to kind of designate the pages like we have. This is starting to talk about how we're going to release these contingencies. So Section 4 is talking about the buyer releasing the contingency to contract for sale. They're only releasing the first of the 2 contingencies, and they're going to do that on or before the contingency to contract to sell deadline that's set forth in Section 2. If they don't do that, obviously it's going to lapse because they haven't gotten their contract and the deadline is passed. So you'll see when you flow down to the signature section, there's an option to do that, to remove just the contract, the removal of the contract for sale contingency, the ability to remove just one of those. And I think this is really important. This will be the greatest learning point for all of us and also for consumers, is making sure they understand there are explicitly two contingencies. And when one is released, that doesn't mean we're definitely closing, that this contingency is removed from the contract. It just remains that one of the two is removed. And it's making it more explicit, I think, to everyone. The next section is creating a date definite by which the parties are going to close. So it's talking about, okay, we've released the contingency to contract to sell. The first contingency is gone. We're going to set a deadline, an absolute closing deadline, by which the contract has to close, or it can be, terminated and made void. And I think this is important because otherwise you can end up in a situation where, like we were talking about, you have four, maybe three, four, five contracts stacked up on one another, and they closings keep getting delayed because one of those closings can't meet the conditions necessary to get it done. And both the buyer and the seller are stuck. They've got an agreement without a deadline. So we wanted to make sure that there was going to be a definite deadline for the closing of the contract. I think the best practice is going to be to set that out significantly from the closing date, maybe set forth initially, give people extra time, but it's going to, need to mirror the language in the contract. And if you were thinking we could close in 30 days, obviously you probably need to have more time in these circumstances because things do happen. But that's kind of a date definite for that to occur. Obviously, it's something the parties could agree later on to extend through a mutual agreement and an addendum, but it is going to set a date definite for that to occur. And then this is a little unusual, but I do want to go over kind of specifically what these signature blocks are intended to do. So the first signature block, which is lines 53 through 62, is where the parties are going to actually execute this agreement and make it binding and effective. So it's going to be where the buyers and sellers execute the form to make this contingency part of the contract. The next section is if the seller is going to cancel the contract pursuant to 3A. That's the immediate kickout. Seller is going to cancel it because they've got another offer that's clean. They're going to provide that to the buyer, and they're going to immediately send the cancellation along with it. We've got another clean offer. We had an immediate kickout. We're canceling it. So this is the section to be utilized by the seller when, again, they've chosen that immediate kickout section, and they're going to terminate the contract. The next section is talking about the removal of the contract for getting their buyer's property under contract for sale. It's not the removal of the closing contingency, only the one getting it for sale. And this is going to be utilized when the buyer and the seller have selected options that allow the buyer to release only the one option. And the buyer will do this. They'll return it. It'll be clear, hey, we've released that contingency, and now we are only keeping our contingency to close. And then finally, the last paragraph, the last execution paragraph, is the removal of the closing contingency. Obviously, I think it's pretty self-evident, but that is not going to be executed until the parties are actually closing, or as an alternative, the parties have negotiated an agreement where the buyer has voluntarily agreed to give that up prior to closing. So obviously, we're talking here in section 3B of the contract. If you go back, if the buyer has chosen voluntarily to remove both of the contingencies in 3B, and they said, we're going to close. It's not going to be contingent on getting a contract. It's not going to be contingent on that contract closing, and we're just going to remove the contingency entirely. The buyer is going to execute both the removal of contract for sale contingency as well as the removal of the closing contingency. I think overall, the purpose of this form, again, it's a big change. It's not meant to confuse people, but it will be confusing initially as we become comfortable with the form. I would strongly encourage folks to really familiarize themselves with this form prior to the time period in which they actually need to use it. It's going to be something that's going to become commonplace in our market. We're all going to get used to it, but it is going to take some time. And I would really encourage you to familiarize yourself with it so that the first time you're looking at it in depth is not when you're presenting it to your client, when they get an offer, or when you're, the buyer of property and you need to utilize it. I would really suggest educating yourself so you'll be better suited to educate your clients when their needs cause this form to be utilized. As always, I appreciate your time. I wish you the best of luck this year and a lot of success in our current marketplace. Thank you.